If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say that you didn't commit a crime,
No,
then you're not pleading
this
guilty.
isn't like, I don't, it's not a game. And I'm not going to let you plead guilty if you're not guilty.
A routine plea hearing suddenly turns into one of the most important moments in court. A defendant walks in with an agreement, but as the judge explains the consequences, the tension starts building. Then the defendant says something that changes everything. The judge stops the plea, refuses to move forward, and makes one thing clear. Court is not a place where you plead guilty while saying you did not do it.
You are Frankie Farias. Mr. Farias, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. This is how you understand this agreement.
I'm sorry.
You have 2 agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record. They're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term. So you need to understand, if you don't understand what a firearm is or what a weapon is, you need to talk to a lawyer because that's one of the conditions. Do you understand? When you pick up criminal cases, there are a lot of collateral consequences, as you now see. It can impact you in ways that you never, ever see. That's why you need to strive to never pick up any kind of cases. And when you pick up multiple successive cases, it kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. That's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. Do you understand? For you to complete this successfully, you have to do a Batters Intervention Prevention Program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to 1 time a week for 8. You don't have to do this. You can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Have an attitude, Judge, is just, I mean, I understand, you know, I messed up. I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, it's just.
And here's the thing, though, Mr. Faris, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
This is a conversation.
No, but Nathan, I want him. How did we treat you? In what way?
I mean, I'm not
Tell
saying
me.
y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20. I made a mistake. I was drinking. It was just a mistake.
Please do not admit to committing the offenses. We actually haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say that you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it.
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
Well, hold on a second. How old is the case? I mean, the case is from 20, it's 510 days old? No. We set the case for trial today.
We'll do that.
That's it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand the way I talk to you now is in hopes that you don't pick anything up in the future, because
I haven't.
do you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every
sure you do.
Same.
But I am one of those persons that means it when he says it.
I'm gonna hit the pause button.
You pick up a case in 2020, and now you pick up a case in 2023.
I'm gonna hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you, but what you're pleading guilty to
No,
carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today and get convicted, which is what you're planning on doing, the second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we.
Oh, I'll just set it today because it'll be long enough that we can have a conversation. Almost
So-
30 or so days, Judge.
Yeah, November 19th.
That's
That's,
fine,
it's over 30 days.
Yeah.
Okay.
It's not that. It's just that I don't remember when Thanksgiving is. Which is a week or two after that, so we're fine.
It's that Tuesday. So it's the Tuesday before.
Tuesday, the week before.
Correct.
We're fine.
Okay, 11/19 it is on both cases.
Is Ramona in the back? Do I need to talk to her?
Yes, no. Well, I'll tell them. But don't let
Oh,
him leave.
Nathan, you're fine. It's a good day.
Ramona.
The next case shifts from a plea issue to a question of safety. A defendant is facing serious allegations involving threats, and the defense asks the judge to loosen the restrictions. But instead of compromising, the judge makes it clear that some conditions are not negotiable, especially when public safety is involved.
Again, Angela, we've gotten in touch with the complaining witness on this case. And
Hello, I'm ADA Colada. I'm filling in for Conrad.
Come up. Yes. Ms. Turner, I truly appreciate your tenacity. I really do. But the allegations to me are serious. And guys, keep it down, please. And I don't know if I'm ready because I don't want something to happen. It's too soon. It's too fresh. I don't want something bad to happen.
is it possible for us to keep the address restriction and just do no threatening and harassing?
That's what I mean. It's the same thing. It's the same thing. That's what,
Because they have no contact at all if we do no threatening and harassing. They can still
don't
communicate,
have
but they,
contact. That's the point, is I don't want you to have contact with her. The allegations are serious. You allegedly threatened to choke, you allegedly threatened to kill the family, do it overseas, and it's in a repeated fashion.
she said today that that wasn't true.
That's
I don't
not what
know
I was
that.
told on the recall. Sorry,
Okay,
that's not what I
okay.
was told on the recall. She said that those statements were prior incidences where he had made those comments, and that the incident in question where he made the threat, the consequences of calling the police, she's claiming that he never made the gesture, but I don't have the body cams to watch it to see if that's actually what was said, which is why we're holding off on making a decision.
So what is your position? Your position is to keep no contact?
My position is no threatening or harassing. Based off of the complaint, it was very clear that she doesn't want the restrictions. And I think that they will contact each other anyway. So rather than setting the defendant up to violate his bond conditions.
No. There's no setting anyone up. We're clear what the consequence is if you try to have contact with her. I don't want you to have contact with her for the time being now. I want you to appreciate the fact that you're not to have contact with her, and I'm warning you, don't do it. There will be severe consequence if you try to have any contact with her, if you try to use anyone to relay any kind of messages. If I deem you a public danger, Mr. Javed, I'm telling you now, I'm going to revoke your bond and I'm going to make it very high. Perhaps in time, yes, but the allegations are there. I find them disturbing and I don't want you to have contact with her. I know that your lawyer has really worked hard for it, so don't blame her. It has nothing to do with her. It's all to do with me. And I'm ordering you now not to have any contact with her. Do you understand?
Yes.
Don't blame her. If you want to blame anyone, you blame me. But for the time being, no means no. It doesn't mean maybe. It doesn't mean I've got kids. It doesn't mean I've got to get my car payment. It doesn't mean I got to get my house done. None of that makes a difference to me. My only concern is public safety. That's it. Do you understand?
Yes.
I'm not ready yet. The allegations to me are very troubling. And I get the fact that people try to either renounce, mitigate, recant, but I'm not ready yet. I'm just not. In time, perhaps, because, I'm always willing in time to, modify. It's just too soon for right now.
Okay.
Are there any kids in the relationship now? Good. Wonderful. So there's just no reason for you to have contact with this person for now. There's no reason. Don't. Time heals all wounds and perhaps we can change it, but for the time being, no contact. Come back in a couple weeks and then we can redo it. And then I want you also to give you guys sufficient time to do a full rip, take time to do it with the right way, not in a rush when you've got other, a gajillion things going on as well. And I appreciate you really coming down to help out as well, okay?
Problem, and I'll make a
So-
note for Conrad to have a more in-depth discussion.
The other thing is I'd like to talk to her as well, before, because I'd like to talk to her to tell her that, the ramifications, not to ever feel any type of fear. No one, absolutely no one should have to live in fear like that. It just doesn't matter. Imagine having to walk on eggshells because of the fear that if you make someone mad, they're going to explode. No one should have to live like that. So, and I'd like to impart that, that's it. All right. So, Mr. Turner, whatever reset you want, if you want to do a week, 2 weeks, whatever you'd like to do, I'm okay. I'm just not ready. And understand that I bet, best probably not the same. Okay. All right. Thanks. All right.
I'm making that note for Conrad now.
Thank you.
This case starts as a simple assault allegation, but the details quickly escalate. What begins as a minor confrontation turns into something much more serious when a weapon enters the situation. The judge uses this moment to explain just how fast situations like this can spiral out of control.
Good morning, Mr. Lopez. Mr. Lopez, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
One more, Your Honor. On September 6, 2024, officers were dispatched to an assault at a residence in Harris County, Texas. Officers made contact with the complainant. The complainant was picking up a DoorDash order, returned to her vehicle, and removed an empty cup and placed it on the floor in the parking lot. The complainant stated that the defendant grabbed the cup, threw it back inside the vehicle, and the complainant placed the cup outside the vehicle once more, and the defendant grabbed the cup, placed the rock inside, and the defendant threw the cup with the rock at her, striking the left side of her face, causing pain. The complainant stated the defendant grabbed her windshield wiper and the two engaged in a verbal altercation. The complainant states the defendant grabbed a handgun from his vehicle, held it by his waistband, but did not point it at the complainant. The complainant stated that the complainant stated to the defendant that she was enrolled in a police academy, was calling 911, and that's when the defendant left the scene.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail. You will not get any more PR bonds. You understand?
Yes, sir.
See that there's no bond set now.
Correct.
You guys want to do?
It's just a misdemeanor, Judge. We're looking at 500 to 1,000.
Okay. What do you think?
We're not opposed to 1,000.
Okay. We'll set it at 1,000. Do you have any open cases now? Are there any open cases now? All right, I will give you a PR bond now, but I'm going to tell you, Mr. Lopez, this is it. I'm not going to give you another one. You violate conditions, do something you're not supposed to. I'm going to do everything in my power to protect the public in every single manner, however I can. So beware that we have eyes on you now. Any false move, we're just going to put you in jail. You understand? You're lucky. One false move with that gun, because it's very tempting. You could be hit with a second-degree felony. God forbid someone else didn't have a gun. I was reading a report yesterday or a couple of days ago where same kind of deal, two people getting at it, one blew the other away, dead.
Sorry.
You never know who's on the other end of that argument and whether they have a gun or not. Got to be careful. Life's way too short for this. For now, I'm going to have you sign a reset with Victoria. We'll get you with pre-trial for your bond and your paperwork, and then we'll have you sign your bond conditions, and then you'll be on your way. You have a lawyer, so we will waive your appearance, but it's your responsibility to stay in touch with JL, and she'll tell you when you have to come back to court. If she tells me she can't get a hold of you because you're gone or you're ducking and dodging phone calls, I will issue a warrant for your arrest. Pick up a new case, violate conditions, same thing. Do you have any questions? Just be nice. It's not hard, So, all right, guys, please.
The final case isn't about what happened. It's about what didn't happen. After being given time to comply with court-ordered requirements, the defendant returns with delays that test the court's patience. This time, the judge makes it clear that waiting until the last minute is no longer acceptable.
I have Carol Ramirez. We're set for an update today. She does have her ankle monitor on. She's registered with IOP. She has orientation tomorrow and she starts Saturday.
Okay. Was there anything else that was supposed to happen?
I'm sorry?
She was supposed to be finished with SOP and now registering and for IOP, right? Wasn't that
No,
what?
she had to start, it's IOP first and then SOP. So she has to do IOP.
Weeks ago.
No. We were here
It was not?
not
No?
too long
Let me
ago. I can pull her up, Judge. Do you have Carol Ramirez? Oh, never mind.
I'll pull her up.
If you get there before me. I'm pulling her up, Judge. She's the one, Judge, I don't know if you remember
No, I
that.
remember everything. Yeah.
Okay.
So I have here on 9/13, this is when we amended the agreement to do the 3 days and then scram upon release and do IOP and SOP. That was 9/13.
Yes, and you told her by the time she comes back, she has to be registered, which she is. She has orientation on Thursday and she's starting on Saturday. That's what I have.
Shatori, we're talking about Carol Ramirez.
Just talked to her. She had a visit with her officer, and at that point, she wasn't registered. She just sent me over the company she registered with. So I'm gonna call them. And
She's still pushing it. Still pushing it. I mean,
she goes on Thursday.
same thing. It's over and over. It's come up, Miss Ramirez. I don't understand why you are still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September 20th is when she went in. And that Monday, I think you reinstated her, Judge.
Yes, Judge, it was September 20th.
She did it. She was released on when, the 21st?
The 23rd. 23rd is when she was released. She was
Released the 23rd. She was supposed to register immediately, starting the IOP. And what day did she register?
Yesterday.
Says her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game, Andrea.
At least
I'm
she's
tired of playing this
registered.
game. It's
Mr.
like,
Sapiens?
you know, when this is what happens when you're too nice. It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered,
No, I mean, I'm done with this. I'm just, what?
let her see if she goes, if she attends? I don't have there's not much that I can say. I don't have much to stand on.
She
But
doesn't take us seriously.
I'm hoping that you will allow, since she's already registered, you'll allow her,
Let's do this. Let's do this.
because she has an ankle monitor on. That's on. It's
I'm
on.
gonna
there.
send her for a drug test right now. I want to see what if anything that she's gonna test positive for. And then right now, I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over. That's it. But if she's clean, then we'll talk about how we go further.
Did I
but-
send her back here?
Yeah.
How long, so I know how to manage everything else that
I
I have.
have your cell phone, right?
Yes,
I'll text you when she comes back
okay.
and I don't know. Just take a seat for a minute.
Thank you, Judge.
Thanks, Andrew.
Seems we've reached what we consider an acceptable agreement with the state, subject to the court's approval. And I understand that you'll want TRAS part of that. And
Or you want to do the PTI agreement?
I'm sorry,
PTI?
yeah. I don't know if it's gonna be that yet. We're subject to the TRAS.
What do you want to do?
Well, she was telling me that you had a condition for TRAS, and that's why I'm.
Probation or for
Yes,
what?
sir, probation.
Okay, it's up to you
I just
guys.
wanted to jam him in the box and all that. I just want to make sure that.
Well, the only thing I'm going to advise you, Mr. Durham, is that you're on bond in this case. It's old, and now you have a bond violation for missing a drug screening. I will give you a pass today, but this is the only one I'm going to give you. If you ever miss another drug screening and they call you to go take a test and you fail to go, I'm going to revoke your bond. Do you understand? You were expected to abide by the bond conditions like everybody else, and when they tell you to go test, you have to go. If you fail to go, then
Yes, sir, and I did apprise him of that.
I'm not going to give you any more passes. This
Yes,
is the
sir.
only get out of jail free card you get.
Thank you, sir.
It's up, if you guys want to do a probation now, we can do it now, and he can just do the TRAS as part of the probation, or you can do the TRAS first, whatever you guys would like to do. I'm amenable to each.
He's really a good guy that got in a bad spot, and I think that'll really help.
Okay, it's up to you, however you guys would like to handle it. I'm game with whatever you'd like.
Yes, sir. We appreciate it.
Sure.
We'll do the TRAS first.
You want to do the TRAS now?
Yes, sir.
Okay. So since he's here, we might as well send him now. That way we
Yes,
can
sir.
kill two birds with one stone.
Yes, sir.
This is an evaluation to see what kind of conditions they would place on you for being on a DWI probation. So that way you kind of are informed of what to expect entering into the probation. If you didn't want to do the probation, you'd have to do another offer. You'd either accept a jail time offer or we would set up a trial. So those are the three different options that you'd have. And I don't know what kind of jail time offer they would give you. That's on them, but
Yes, sir.
subject to us accepting it, of course. But
Yes, sir.
this way, this would give you kind of a look into what requirements you would need to do to successfully complete a probation. So
Yes, sir. We appreciate it, Judge.
since you're here, there's no better time to send you now. And then, so what we'll do after that, we'll set you off after today, 3 weeks to give you time to get the TRS back, and then we can talk about how to go forward.
Yes, sir.
Don't miss any more. Okay.
We won't do it. Thank you so much. We
Take care.
appreciate it. Thank you.
Katrina Rasul. Morning.
Good morning.
Ma'am, you were wanted out of the state of North Carolina for felony probation violation, 4 counts as alleged. Are you waiving formal extradition, ma'am? Okay, we wish you the best of luck.
Thank you.
Thank you. Thank you.
Go to Ms. Ramirez.
Absolutely.
The state position is that we follow the recommendation of the
Yes.
probation department. Either feels A, she's reached a point where they can no longer help her and she needs a higher level of care than the probation department can give her. Or B, if the probation department feels that they can still treat her, we follow the recommendation of the probation department. Me being Texas.
And there was a 6-month extension, but her last been under 7 months.
But Judge, if she registered for the classes, there will be completed in 6 months.
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, 2 to 3 times a week. So
I told her last time we were here.
now when we approached, because I was with her, Judge.
I told
No, I
her.
was with her and I don't remember you saying that.
I told her what you need to have done, and then this is what you register for. When you come back, this is what we're gonna end up doing. Regardless, look, regardless.
What I'm saying is, since the probation department feels that they can help her, if she can register to one of the 3, and I'm gonna bring her up here if you decide to allow her to continue, I'm gonna bring her up here and we all talk, so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's childish because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
This is all predicated on if the court does not rescind its order for supervision.
What I'm going to do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that. And then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying.
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage just I don't think that this is right. And I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now is not what this program is designed to do. And it really violates the spirit because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world. And you've done everything against that. I mean, for you to sign up for the class 1 day before court, it's just, it hurts. And it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, not 2 weeks, not 3 weeks, 4 weeks. So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately set your case for trial. You have 1 week to sign up for the class that's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
Yes, sir.
Judge, just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program 3 times, IOP 3 times a week. What are the requirements? Is SOP once a week or, okay.
She has to complete IOP.
Right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to have, right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about, exactly a week.
Okay, do I have it
Next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay.
Stay, there's nothing further, Judge, for the court.
See you in a week.
Thank you, Judge.
Every case in this courtroom comes down to one thing: consequences. A plea only works if the defendant accepts responsibility. Bond conditions only work if they're taken seriously. And second chances only matter if they're used the right way. Throughout this hearing, the judge isn't just explaining the law, He's drawing a line between opportunity and accountability, whether it's refusing to accept a plea, enforcing strict no-contact rules, or giving a final warning before taking stronger action. Each decision shows how quickly things can escalate when those boundaries are pushed. The real question is, where should that line be drawn?